I declare the meeting open to the public.
That's the chair of the committee.
That's exactly what it is. Oh yes, yeah. I wish I was out.
Just to remind you, members and those in the public gallery, that you're welcome to use mobile devices. Don't get too excited at that, as long as they're in airplane mode and all devices are muted. You can also connect to the Assembly Wi-Fi, and the password details are available on the gallery rules. It's not permitted to take photographs or record any of the meeting. Okay, all three oral evidence sessions today will be Hansarded. And with that, we're going to move on to agenda item 1, which is apologies. And I have apologies from the chairperson, Paul Frew, who's happily in France, and Michaela Boyle. So, are there any other apologies in the meeting?
Michaela Boyle.
Yeah, yes, we have her. Thank you. That's great. And if there's no other, then we shall move on to item 2 on the agenda, and that's the draft minutes of the meeting held on the 9th of June. Members, these minutes of the meeting held on 9th of June 2016 are at pages 6 to 10 of your meeting pack.
Great.
So I'm just going to ask if members are content, so that's agreed. Then, if so, then I'll sign those minutes. Right. That's great. Okay. So moving on to item 3, matters arising. Item 1 is the forward work programme. Members, an updated forward work programme is at pages 12 to 16 of the meeting pack. The oral evidence session with Professor Stark on coercive control in the context of domestic violence and abuse has been scheduled for the meeting on Thursday, the 30th of June. So look forward to that. Members, the Department has advised that the written briefing paper scheduled for the meeting on the 30th of June on a proposed consultation on PACE draft qualifying offences amendment order will have to be rescheduled to a later date, as an agreed position with the Home Office on the extent of the amendments to the current list of qualifying offences across jurisdictions has not yet been reached. Okay, so moving on to item 4, and that's the overview briefing of the Northern Ireland Courts and Tribunals Service. Members, the officials will attend to provide an overview briefing on the Northern Ireland Courts and Tribunal Service. The relevant section can be found in the first day brief, and that's at pages 71 to 73 of the meeting pack. So I welcome Ronnie Armour, Chief Executive, Peter Lunny, Head of Court Operations, Sharon Hetherington, Head of Corporate Services, and Elaine Topping, Head of Tribunals and Enforcement of Judgments Operations, Northern Ireland Courts and Tribunals Service, to the meeting. And can I advise you once again that the session is being recorded by Hansard, and the transcript will be published on the committee page as normal. So can I invite you, Ronnie, to briefly outline the remit and responsibilities of the NI Courts and Tribunal Service and the current key issues?
Thank you, Chair. I welcome the opportunity to come to the committee today to brief you on the work of the Northern Ireland Courts and Tribunal Service. As you said, I'm joined by my 3 senior colleagues from the agency. In making my opening remarks today, I want to provide some background briefing about the Courts and Tribunal Service before saying a little bit about our priorities, our challenges and our opportunities. As the committee will know, the Courts and Tribunal Service is an agency of the Department of Justice comprising 668 staff working at 19 venues. 89% of our staff work in frontline posts, administering in excess of 120,000 cases per annum across all of our business areas. We have a forecast annual expenditure of around £77 million, and through the Court Funds Office we manage around £290 million, which is held in court on behalf of some of the most vulnerable members of our society. We support 15 tribunals, the most recent addition being the Planning Appeals Commission and the Water Appeals Commission, which transferred to us under NICS restructuring on the 9th of May. Administrative support is also provided to the Coroner Service, the Parole Commissioners, and one other area that I should mention is the Enforcement of Judgments Office, where on average we're recovering around £10 million in debt per annum. Our primary objective is to deliver high-quality services that support an independent judiciary and meet the needs of our customers. There are currently 72 salaried judicial office holders, 62 deputy judicial office holders, 149 lay magistrates, 39 parole commissioners and 349 tribunal members. The work of the agency is governed by a framework document, and I, as accounting officer, am supported in the discharge of my duties by an agency board, which includes 4 judicial representatives nominated by the Lord Chief Justice, 2 non-executive members and a representative from the Department of Justice. Naturally, I also work closely with the Lord Chief Justice. Our corporate and business plans set our strategic objectives, and in delivering those objectives, whether in terms of administering our routine business or the implementation of our modernisation programme, our priority is to deliver better outcomes for citizens, to effectively support the judiciary, to work in partnership with our stakeholders, to ensure a fit-for-purpose estate and to manage a skilled and motivated workforce. Turning briefly to the challenges we face, budget uncertainty remains a significant issue of concern. Since 2010, we have seen our funding allocation reduce in real terms by £15 million. Significantly, £8 million of that figure has been removed since the 1st of April 2014. Operationally, our staffing complement has also reduced by 117 posts, or 15%, since 2010, and 88 of those posts have gone in the last 2 years. As a result of the voluntary exit scheme, we have also lost a significant amount of operational expertise. Maintaining our estate is also challenging, and there is a need for capital investment, not least in the North West, where Londonderry Courthouse is 200 years old this year. Across the estate, we're currently primarily focused on essential maintenance only. As the committee will be aware, following a consultation process, the previous Justice Minister announced his decision to close 6 courthouses as part of a programme to rationalise the court estate. That decision is now the subject of judicial review proceedings, and consequently Minister Sugden has agreed that no courts will close pending the outcome of those proceedings. Looking to the future, during the next 12 months we will establish a new fine collection and enforcement service created under the provisions of the Justice Act Northern Ireland 2016, and we will continue to work with our colleagues in the Department of Communities to transfer responsibility for the appeal service from that department to the Department of Justice and the Northern Ireland Courts and Tribunals Service. These changes will mean that our staffing levels will increase by around 160 staff, or 24%, in the next year. In addition, when the necessary funding is obtained, we will also be required to establish a legacy inquest unit to support the Lord Chief Justice and the presiding coroner processing outstanding legacy inquest cases. Regarding the opportunities that are open to us, let me just highlight a few. Our modernisation programme is aimed at ensuring we are structured and resourced to provide efficient and effective service delivery to court users. The programme comprises 5 projects which are focused on rationalising the court estate, reviewing our service delivery models, reforming the Court Funds Office, increasing our income and developing our workforce strategy. Focusing briefly on income generation, we will be coming back to the committee in the autumn to brief members on the outcome of our consultation on our proposals to increase court fees for civil business. In addition, as we implement the provisions of the Justice Act, our service delivery will also be improved through the introduction of measures such as single jurisdiction and statutory case management. The recommendations contained in the Access to Justice review, for example in relation to dispute resolution and mediation, when taken with the findings and recommendations in the Justice Committee's report on justice in the 21st century, and the work that Lord Justice Gillen is undertaking as part of his Civil and Family Justice Review, all highlight the potential for us to continue delivering improvement. It is our intention, working with others across the justice system, to focus on the development of digital and problem-solving justice, both of which, if properly resourced and coordinated, present opportunities to increase the effectiveness of the Courts and Tribunal Service and the wider justice system as we strive to provide better outcomes for citizens. Chair, this is a very quick summary of what we in the Courts and Tribunal Service do and are seeking to do in the context of the challenges we face. We're of course happy to take questions, but before I close, I wonder if I may provide one further update in relation to a question that was raised by Mr Frew at your meeting last week, when he asked for an update on the current position in relation to the backlog in the Crown Court as a result of the legal aid dispute. The legal aid dispute lasted from the 5th of May 2015 to the 12th of February 2016. During this period, 1,040 cases were committed to the Crown Court. At the 10th of June 2016, 508 of those cases had been processed and finalised, and 532 remain in the system. While this represents significant progress, given that the Easter recess occurred during this period, it's clear that there is still work to be done and some way to go before we clear that backlog.
Okay, thank you very much. That'll be very useful. I'm sure I'll be glad to have that response as well. Just in relation to the position of the proposed closure of 6 courthouses, thank you for that update. That's also very useful. Who took the judicial review?
The judicial review has been taken in relation to Strabane, Ballymena and Lisburn courthouses. It's been taken by individuals in Lisburn and Ballymena and by solicitors in Strabane.
Okay, thank you for that. Okay, could you tell us a wee bit more about the Enhanced Domestic Violence Court with the Perpetrator Intervention Programmes? Is there a timescale for the development and implementation of this?
Well, as you know, up in Derry Courthouse, Judge McElhone has been very successfully working with Women's Aid in terms of his listing arrangement. The previous minister had discussions earlier this year with the Lord Chief Justice about rolling that programme out beyond Derry. And as a result of those discussions, some work was commissioned to look at the perpetrator programme and how we could have better interventions at an earlier stage, for example, in relation to individuals. That work has been taken forward in a different part of the Department of Justice, not by the Courts and Tribunal Service, but it is progressing, and we would hope to be reporting back in terms of that and the wider problem-solving justice issues later this year, probably towards the end of the summer.
Okay, so you are looking at a plan to roll out across Northern Ireland? Yes,
that has been discussed with the Lord Chief Justice, and that is something we would wish to do in the fullness of time. Yeah.
Okay, that's welcome. And what about stakeholders? Is there engagement?
Yes, the work is being led primarily by the Community Safety Unit within the Department of Justice, and there has, to the best of my knowledge, certainly been stakeholder involvement in that, and obviously Women's Aid are a key player in terms of the delivery of the work that's currently ongoing in the North West. Okay,
thank you for that. You've indicated that NICTS currently administers the Tribunal Appeal Service on behalf of the Department for Communities under a service level agreement.
That's right.
Are there any plans for the Courts and Tribunal Service to take on statutory and financial responsibility for this? And if so, what's the timescale?
Yes, we're working with our colleagues in the Department of Communities to give effect to the transfer across. The plan and the hope is that we will be in a position to do that in April of next year. There's still some work to be done, not least in terms of a transfer of functions order, but we're working very actively with them to try and make it happen by the spring of next year. Okay,
thank you. And reform of the Tribunal Service, long overdue. Are you responsible for that, or does that fall to the Department?
No, that falls to the Department, to the Access to Justice Directorate. Okay. Our role is simply to administer the tribunals, and we don't have policy responsibilities.
Okay, that's great, thank you. If Trevor Lunn?
Thanks, Chair. Thanks for your presentation. Just one thing, you mentioned the amount of money recovered through the Enforcement and Judgment Office of about £10 million, which sounds impressive, but what What do you have any idea what percentage that would be of the total amount of judgments handed down?
I don't, I'm afraid off the top of my head, but I can certainly look into that and we can come back to the committee on it, but I wouldn't have that figure, to hand today.
Well, I didn't think you would, but I'd be interested to see it, you know.
Okay.
It sounds like an impressive figure, but if the total amount was 100 million, maybe it's not quite so.
We'll certainly come back to you on the detail, but sorry, I don't have that information.
Thank you.
Okay. Sammy?
Thank you, Chair. Thanks so much for the presentation. Ronnie, you mentioned about the voluntary exit scheme and how that impact will impact on key personnel. What impact will that have on the courts and tribunals for the future?
I think we're going through a difficult phase at the moment, insofar as we've seen a very significant number of colleagues leave us in the last 6 months, and that has required us internally to do quite a lot of work in moving people around to fill the core posts. I don't think in the long term, in answer to your question, that it will have a detrimental impact, but I do think on the short term it is challenging for us to manage the business. But so far so good, if I can put it that way. To you.
Okay. Thank you. Thank you, Chair.
Roy?
Just following up River London's question, would you accept if you were a business, you would know exactly how good you were at collecting the debts that were out there, and that this is something which should be reported to you monthly at the very least?
Well, I think we are good at the work that we do. I don't have the figure to hand that Mr. Lunn has asked for today, but we can certainly get that. But we take our responsibilities extremely seriously, and obviously in terms of all that we do, we're answerable to the courts for the service that we provide. So I think we are providing a good quality service, but I just don't have the exact figure to hand. But we'll get that, as I said.
I think I last met you at a Public Accounts Committee hearing.
You did.
And I think one of the important aspects was find defaulting, and the huge cost of putting people who default into prison for a few days, further cost the public purse. And thankfully, with the Justice Northern Ireland Act 2016, there is now provision for attachment of earnings orders and deductions from benefits. Have you started to do that as of yet? And if so, or have the courts started to make these judgments? What has been, how have you assessed the success or otherwise of the process?
Well, the work at the moment is to establish the fine collection and enforcement service, and now the legislation is in place. I'm leading a project to establish that service by the end of the year, early 2017. And Peter might want to add something, but in effect we're not at the stage of doing it yet. We're now at the stage of establishing.
I'm just conscious this has been operational in England and Wales for several years, and we're way behind. Does it really need another 6 months to get something up and running to save money?
No, I agree with you. There has been a lot of preparatory work. There's been a considerable amount of work done with the DSD in relation to the deduction from benefits. A lot of preparatory work has been done around developing the structures for the new civilian fine enforcement service. It will undoubtedly bring a good range of benefits. We'll have more collection methods available to us, but as well as that, for those cases which do go into default, we'll have a broader range of methods for dealing with that. We'll have the supervised activity orders. At the minute, we are still working with the transitional arrangements which we had to implement following the judicial reviews, and I think there's no doubt that they're clunky. So it is in our interest to try and get the new arrangements in place as soon as possible, and so, as Ronnie said, we're hoping that'll be on stream early next year.
What date's early? Is that January or is that June?
We're aiming for January.
Yeah.
Okay, thank you.
Thank you. Claire?
Thank you, Chair. Just a very quick, easy, simple one. Just you were talking about a consultation you have out at the minute on increasing fees. Was it for the civil court?
That's right, yes.
When is the consultation out to?
The consultation closed last week.
Oh, right.
We are now beginning the process of analysing the responses with a view to coming back to this committee probably in September.
Missed that one then.
Okay. Up enough, Claire. Alex?
Thank you. Could we return first of all to this issue of administrative support to the Coroner's Court arising from the interventions of the Lord Chief Justice around inquest? Could you indicate, given the scale of that undertaking, if the Lord Chief Justice is able to fulfil his ambition in that regard, can you indicate what the scale of administrative support is going to be in terms of personnel and budget lines in order to service the Coroner's Court from the legacy inquest?
Yes, I mean, of course. The Lord Chief Justice assumed the presidency of the Coroner's Courts, as you know, in November of last year. He very quickly set to work in terms of looking at, in particular, the legacy inquest that you refer to. And Lord Justice Weir, on his behalf, conducted a very comprehensive and very detailed state of readiness review in January. On the basis of the outcome of that, and having had a number of discussions, the Lord Chief Justice brought forward his proposals in terms of the 5-year plan that he has. Now, that plan is obviously predicated on the establishment of a legacy inquest unit. We estimate at this stage that there would be around, I think, 32 support staff working in there.
New staff?
Sorry?
New staff or redeployed staff?
Well, we have a very small number of people within the Coroner's Service at the moment who are providing support in terms of some legacy work. So, you know, they're there, but the bulk of the staff will be new staff once the funding is in place to do that.
And the funding requirement is what?
Well, the funding requirement in terms of that legacy inquest unit would be, I can just find the figures here for a moment, would probably over a 5-year period be around 16-17 million. That's just for the legacy inquest unit within the Courts and Tribunal Service.
And is the paper that the former Minister of Justice tabled at the Executive, does that paper capture your financial requirements in terms of legacy as well as the Lord Chief Justice's?
Well, the bit I'm talking about, the 17 million, is mine and the Lord Chief Justice's, but we obviously provide the administrative support, and the answer to that is yes. And that bid is a composite bid, of which we are certainly part, yes.
The next question might be a difficult one. In the discussions around dealing with the past, when it comes to, for example, the proposal to set up the HIU, there's been some conversation about who can or cannot be an investigator in respect of the HIU, because clearly there are issues, certainly from where I sit and from where many people sit. Indeed, last week the Chief Constable confirmed that those officers that were going to, or those investigators who were going to take forward the steak knife investigation would not have any Northern Ireland policing background. Do you have any issues within your service when it comes to the recruitment of staff into your legacy support unit, help the Coroner's Court? Do you have any issues of that nature in terms of your human resource and recruitment policy?
I think well, first of all, I've not been involved in the development or the establishment of the HIU, so I can't comment in terms of that. In terms of the legacy inquest unit, I think there would certainly be similar issues of concern to the families, but it's not an issue that we have addressed thus far, in that we haven't established the unit yet, because we're still waiting on the funding. But it is something that we are mindful of.
But I presume that in order to come forward with a bid through the Minister of Justice, you were working through the number of staff and the issues around the recruitment of staff and so on and so forth. Have you come to a conclusion about what your recruitment policy should or should not be?
Not at this stage, and that's something obviously we would want to take forward and consult with the Minister and the Lord Chief Justice on as well. So at this stage, no, we haven't formalised a firm policy on that, but we're certainly alive to the issue. I think there will be different areas of responsibility within the unit. I mean, a lot of the staff will be involved in administrative work. Some will be involved as coroners investigators, and I think that's more where the issue is likely to come forward. But we haven't, we haven't formalised a policy on that.
I know that you acknowledge that that is an issue, and I would, and the committee would like to hear subsequently what the policy is going to be, because obviously there's issues.
Okay.
You said at the end of the summer that the work in terms of problem-solving courts might be concluded. That's not very long away.
Well, I didn't say concluded.
Right.
I said we might be in a position by the end of the summer to give a further update in terms of where we are with that. I mean, the Department of Justice are taking forward one of the Pathfinder projects, and that project is built around problem-solving justice. So what I'm saying is, by the end of the summer, we would hopefully be in a better position to give the committee a bit more information on that. But it'll certainly not be established by the end of the summer.
I'm sure if the Chair was here, or Vice Chair, he would reflect the views of the last committee in terms of problem-solving court seeming to have a very broad level of support. And if that's going to be part of the quality of this mandate, then budget lines and commitments in the programme for government need to be firmed up by the end of this year. All I'm pointing out is that I know there's good work going on in this regard. It needs to get firmed up, in my view, so that it is part of the architecture of the programme for government with the funding budget lines. So I hope that the Minister is in a position to bring forward something more than a report on where things are by the end of the summer. I will actually be scoping out what will be done in this mandate as opposed to what might be hoped for. Could you go back to what Roy was saying? Could we have a profile? Because I only came on the Justice Committee towards the end of the last mandate. Just a profile of those people who are going into custody for fine default in terms of numbers, age, gender, repeat offenders. I'm sure you've got all that core data. I'd just be curious to see that. And my final question is, the one thing that surprised me that you didn't mention was victims in terms of the work of the service. And at the end of the day, courts have to be first and foremost about victims. So could you indicate what is the work that you undertake in that regard?
About that?
Yes, we are. We have a number of pieces of work going on around victims. I mean, the main issue that we're trying to tackle is around the waiting times, which was an issue which was very high on the agenda of the last Justice Committee. Working together with the PPS and police, there have been a number of mechanisms put in to try and make sure that witnesses that are attending court in Laganside are kept better informed and released as early as possible, but trying to broaden that out. We've been working with the judiciary around protocols to try and ensure that when witnesses are called, they are kept informed, that if their case turns into a plea or folds for whatever reason, that they're informed as soon as possible and then released, and that overall their waiting times come down. I think the waiting times in Northern Ireland from the NIVOS survey compared quite unfavourably with similar statistics for England and Wales, and I know that's an issue that the committee were keen to tackle, and hopefully we are starting to make some progress on that front.
One of the reasons I mentioned it, Chair, is there's a case in the media today where another agency has let down a victim, let down a family, and therefore I think it's probably timely just to flag that issue up. Maybe we'll get some written briefing on the work that you're talking about,
I think
as well as the practical on case by case support to individual victims in terms of their journey through the courts.
I think obviously during the last mandate, the PPS and the police worked closely together to develop their victim and witness care unit arrangements, and that would be the main point of contact between witnesses and the coming to court. So we could probably try and get some material for that as well.
Thank you.
Much. Any other members' questions?
Just one quick one. Just going back to the Enforcement of Judgments Office, they're not responsible for fine collection. Sure, it's just civil judgment. Yeah.
The new fine enforcement collection service will take that responsibility when it's established.
Okay, well, if there's no other questions, can I thank you very much for that overview? It's very useful. Thank you very much.
Thank you.
Members, so moving on to agenda item 5, which is the overview briefing from the Justice Delivery Directorate. And officials will be providing an overview briefing on the Justice Delivery Directorate, and you can find the relevant section in the Thursday brief at pages 83 to 94 of your meeting packs. Okay, so can I welcome along Leanne Patterson, Director of the Justice Delivery Directorate, Glyn Capper, Head of Financial Services Division, Mary Madden, Head of Personnel and Office Services Division, and Ray Murray, Head of Information Services Division, Department of Justice, to this meeting, and advise you as well that the session is being recorded by Hansard and the transcript will be available as usual on the committee webpage. So can I invite you, Leanne, is it to briefly outline the remit and the responsibilities of the Justice Delivery Directorate and the current key issues.
Okay.
Thank you.
Thank you, Chair, for the opportunity to provide an overview of the work of the Department's Justice Delivery Directorate. I'm accompanied today by my 3 Deputy Directors, Mary, who heads our Personnel and Office Services Division, Glyn, who heads our Financial Services Division, and Ray, who heads our Information Services Division. Mary and Ray will shortly give you a flavour of the work undertaken within their business areas, and Glyn and I will be briefing the committee on the Department's finances directly after this session, so Glyn will give Financial Services Division a lighter touch during this session. I will focus comments on the overall role of the Directorate and on several business areas that are not represented at the table today. So the work of the Justice Delivery Directorate is primarily to provide a range of corporate service functions to colleagues across the Department and its agencies. We also have responsibility for ensuring that the Department has good governance and financial management structures in place, and that our arrangements are efficient, accountable and transparent. The Directorate has 5 business areas: Personnel and Office Services, Financial Services, Information Services, and then Compensation Services and Corporate Secretariat and Internal Audit. And in total we are a staff of just over 300. Key achievements for the Directorates in the last mandate have been the establishment of corporate shared services across the Department. We now have shared service centres for finance, HR and information services, which provide services not only to the core department but also to its agencies, and are continuing to introduce shared services across other corporate services such as information management. Access NI's delivery of a new system facilitating online applications for criminal records checks has improved turnaround times and reduced costs. And during this mandate, we will be working to deliver a portable disclosure service towards the end of this year. A further important achievement has been the careful financial management of the departmental budget, which is both complex and varied, and further briefing will follow in the next session. Before handing over to colleagues to talk about their own areas of responsibility, I'd like to take the opportunity to brief the committee on the work undertaken by Compensation Services, Corporate Secretariat and Internal Audit. Briefly, Compensation Services, which was formerly an agency, was brought into the department in April 2013. And the work of Compensation Services is demand-led. The branch delivers a frontline service to victims of criminal injury and criminal damage, and it administers 4 statutory compensation schemes. 3 relate to criminal injuries and 1 relates to criminal damage. In 2015-16, almost 11 million was paid in compensation, 2 million relating to criminal damage and 9 million for criminal injuries. And in recent years, the volumes of new claims for both injury and damage have shown a reducing trend. So since 2010-11, criminal damage claims have reduced by 56%, recognising a downturn in violence and major incidents, and criminal injuries claims have reduced over the same period by around 35%. So Compensation Services is currently working to introduce a new case management system as part of modernising justice, and this project is part of the wider NICS digital transformation programme also, and its intent is to deliver improvements to victims along with the facility to apply for and track progress of claims online and to exchange information via a secure portal. So turning briefly to the review of the schemes, in the previous mandate, the Department reviewed both the criminal damage and the criminal injuries compensation schemes. And following public consultation, proposals to reform were presented to the previous Justice Committee last December. Subject to the approval of the new Justice Minister, Compensation Services is preparing a draft of a new injury scheme, which could, again subject to ministerial approval, be brought to the committee later this year. The new scheme, once fully implemented, could deliver annual savings estimated at £3 million, part of which will be because of the introduction of the new case management system also. Our current thinking is that we would revisit the reform proposals relating to criminal damage scheme when the proposed injury scheme is implemented. Another business area not represented here today is Corporate Secretariat. This comprises a small team whose work primarily supports the work of the departmental board, and the branch is also responsible for the appointment of independent board members and public appointments, as well as leading on a range of corporate initiatives. Finally, also within the Justice Delivery Directorate is the department's internal audit function. There are 9 qualified internal auditors within this team, and they provide services to the core department and the majority of its agencies, NDPBs and arm's length bodies. The only exceptions are to the PSNI, the Policing Board and the Office of the Police Ombudsman for Northern Ireland. The head of internal audit reports directly to the Permanent Secretary or to the agency or NDPB Chief Executive and to the audit committees of each organisation. So that's a very quick tour of the wider span, and I'd like now to invite my Deputy Directors to give you an overview of their work. I'm turning firstly to Mary.
Good afternoon, Chair, and thank you for the opportunity to present an overview of the work of Personnel and Office Services Division of the Justice Delivery Directorate and the important services we deliver to the business areas across the department and its agencies. Although the division consists of 4 discrete branches, each headed by a Grade 7, there is a working synergy between each of those branches. And the 4 are HR Operations, which is headed by Jackie Wallace, HR Customer Services, which is headed by Gillian Ardis, our Corporate Services is headed by Janet Johnson, and our Estate Management is headed by Cathy Walker. The division provides a range of services to the department and its agencies, such as strategic HR support in all personnel matters, including on performance management, vacancy management, promotions, pay remits and pay, sick absence, grievance and dignity at work matters. It also leads on learning and development, including well-being, and is responsible for change and transformation. On the corporate services side, we deal with facilities management, health and safety and sustainability for the core department, as well as leading on the department's estate strategy programme. And the division is also responsible for security, including national security vetting. On the HR side, we provide to the department and agencies those services through a shared services model. The HR team has recently restructured to deliver those services along functionality lines, and there are 6 functional areas. We have a resourcing unit, a management of sick absence unit, an information and support, a pay unit, a transformation unit, and learning and development. The drivers for this change have been both internal, because we're continuing to provide a HR service in a changing environment where staff levels have reduced, mainly due to the recent voluntary exit scheme, but where we have budgetary pressures too. And external drivers, which is preparing the department for the Northern Ireland Civil Service HR Centre of Excellence, which is due to be launched next year in April. There remains very much, this area remains very much a work in progress and one of the key priorities for the division going forward. In the past few years, we've been dealing with a number of legacy HR matters, such as the alignment of Youth Justice Agency non-general services staff onto NICS terms and conditions, including pay and pensions. and the recent agentisation of the Legal Services Commission last year on the 1st of April, where all staff employed there became Northern Ireland civil servants on that date, and we had to align their pay and terms and conditions to the Northern Ireland Civil Service too. The Department also participated in the NICS Service-Wide Voluntary Exit Scheme, which saw 387 staff leave the Department during 15-16, and we're working with colleagues in the various business areas to redeploy staff in the Department to posts deemed to be business critical and closing other posts that we can no longer fill. On the corporate services side, as Leanne has previously mentioned, we're also implementing a shared services approach across all of its activities. We've already begun to centralise the national security vetting functions by merging NIPS, prison service and DOJ functions, and we've commenced our review into procurement and contract management functions to see how we can better deliver those services too. On the estate management, our team there was established at the end of 2015 and is responsible for the estate strategy programme and the management of the accommodation and the leases across the departmental family. The 5-year plan is to reduce the size of the estate and to address the high leasing costs and moving as many staff into the Department of Finance freehold buildings, which is in line with the wider NICS estate rationalisation plans. Looking ahead, the division faces a number of challenges and opportunities, and some of the key areas are sickness absence continues to be a challenge for the department, and in restructuring, our top priority will be managing the sick absence through a newly established unit within the division, which will work much more collaboratively with the line managers. Embedding the HR shared service model, which we started at the 1st of May, and ensuring a quality HR service continues to be provided across the department and to our agencies. Preparing both the department and the division for the move to the Centre of Excellence in April next year, and consideration of the future provision of HR services through HR Connect, which will incorporate payroll and rostering for our prison service operational staff. In closing, I hope this brief overview has provided members with an insight into the services of personnel and office services, and I'm happy to take questions and provide further clarification at the end of our briefing. At the moment, I will hand over to Ray.
Good afternoon, and thank you, Deputy Chair, for the opportunity again to present the work of my division. Information Services Division's remit covers a mixture of external and internal services. The division consists of 9 branches, each with their own branch head. 5 cover information and communication technology support for the department and its 5 agencies, as well as Causeway, which is the shared service criminal justice system. Each of these 5 Grade 7 heads of branches are qualified ICT professionals. They are overseen by a Chief Technology Officer for the department who reports to me. Of the other 4 heads of branches, 1 heads the Access NI Disclosure Service, another the Minister's Office, and 1 is the Press Officer for the DOJ Press Office. In addition, the Chief Information Officer for Records and Information Management for the department also reports to me. Therefore, the main internal support services that we provide are information and communication technology, line of business system support across the DOJ and its agencies, technical support for the Causeway Criminal Justice Shared Service System, the main system supporting criminal justice in Northern Ireland, information and communication technology security, records and information management policy and support, and provision of the main contact for wider Northern Ireland civil service and UK ICT network and connectivity support services, and also programme and project management support services. The main external facing public services my division provides are Access NI, the disclosure service which provides criminal record checks to applicants for employment purposes in the support of protection of children and vulnerable adults, Freedom of Information and Data Protection Act central policy and responses as part of the Department of Justice Information Disclosure and Legislation Compliance, and Departmental Complaints Officer role and central policy handling. In addition, Information Services Division includes support for the Minister's Office, including Assembly question support and targets, and the Press Office for external communication. Looking forward, the main service challenges facing my division in the next year are providing existing support to frontline services to acceptable and secure levels in terms of information and communication technology, implementation of an update service, portable disclosures for Access NI at the end of this year, preparing the Department for the implementation of new European data protection regulations, and supporting the Department of Justice in meeting Legislative Assembly or NICS requirements and targets, such as those mentioned, Freedom of Information, Data Protection Act, Assembly questions or complaints. Also, security of information and communication technology systems and data against emerging threats such as cyber attack. Further use of Northern Ireland Civil Service wide shared service or centralised service is a big challenge for us again, and innovation and digital transformation services. Nothing stands still in information and communication technology. That's a quick tour of the table in terms of my service, and again I'll be happy to take any questions at the end of our briefing session.
Thank you.
Hand over to Glenn.
Thank you. Financial Services Division provides a range of financial, economics and statistical services to the Department. As Leanne mentioned, last year we introduced a financial shared services model. So as well as the core department, my division now provides financial support to the Prison Service, Youth Justice Agency, Forensic Science Agency and Legal Service Agency, as well as Criminal Justice Inspection. One of our main areas of work is managing the department's overall budget and supporting directors and agency chief executives in managing their element of the budget, and we're due to say more about that in the next session. The division also produces the department's annual report and accounts. Indeed, we're in the final stages of preparing 8 sets of accounts for 2015-16. It also pays our suppliers using Account NI, the NICS Financial Shared Service. The division's Analytical Services Group provides statistical services across the department and its agencies, something that's an increasing focus as this underpins our programme for government indicators. And finally, the economics team supports the department in appraising and evaluating its spending decisions.
So, Chair, this concludes our overview of the work of Justice Delivery Directorate, and we're very happy to take any questions that members may have.
Good, thank you very much, all of you. I suppose straight off, Leanne, your directorate provides support services and other central services to the department, so I assume you're not classified as frontline services and therefore face budget reductions. So what can you tell us more about what measures you've taken to improve efficiency and effectiveness, both within the directorate and across the department and its NDPBs?
Certainly. You're right in saying, Chair, that we're mostly support service. We have a couple of frontline areas such as compensation services and Access NI, but most of what we do is in support. So towards the second half of the last mandate, shared services has very much been our agenda, and we've brought together, so for example in Glyn's area in finance, previously where we would have had a departmental finance team and then 4 agency finance teams. We've brought all of those together within Financial Services Division, and through doing so we've managed to produce efficiencies from doing that, because we're not replicating work. That journey had already been followed to some degree the mandate before last, really, under Ray's division, where again we've got a large shared service centre, and all of this is to stop us having sort of pockets of back office support functions and to make ourselves more efficient in terms of economies of scale. We'll see in the next session that the core department did take the largest share of the cuts in the last mandate, and rightly so, because the ministers views were to protect the front line as much as possible, so we did do most of our cuts in back office support functions. It's quite staff intensive, the corporate services, as you'd imagine, because we don't have programmes as such. It tends to just be bodies doing jobs. So in terms of going forward, there's a little bit more to do in terms of making ourselves more lean, but our scope for actually reducing too much more and still carrying out our critical functions is quite limited.
And it was mentioned, Mary mentioned the Northern Civil Service HR Centre of Excellence. Can you tell us a bit more about that and what benefit it will be to the department?
Certainly, Chair. I'll maybe pass to Mary because she's closer to that.
Thank you. This is an initiative that has been part of the wider NICS reform. led by the head of the civil service and the permanent secretaries. It's part of the drive in reducing the 12 departments to 9, and it's also a recognition that we should have more centralised services right across the department. So in next year, all of the HR services that are in each of the 9 departments will be brought into the centre under one, into one area. So for us in the Department of Justice, we are preparing ourselves and our HR provision to go seamlessly towards that new establishment of the Centre of Excellence, which is scheduled to start operation in the 1st of April next year. That means that in line with all of the departments, there will be one area where HR services with consistency of approach. There should be, as a result of that initiative, a much more streamlined HR services right across the board. I think efficiencies will flow from that, but initially it's really to ensure consistency of approach and a broad service for all of the HR family.
Better way of working?
Yes.
Okay, thank you. Yeah, we recently heard from Northern Ireland Prison Service, this committee, and when the recent data breach was mentioned, they said it was a department responsibility. So can you tell us how the breach occurred and what measures have been put in place to ensure it doesn't happen again?
Certainly. Firstly, I'd like to say that from a departmental point of view, we do take information security very seriously. It was a very unfortunate incident in terms of where the whereabouts, where it came from. We're in the process of moving towards a shared service for data handling across the department. We're moving it into a team within Mary's division, and therefore we're bringing together the teams from the agents into the core. We were in a transitional period for doing that, and unfortunately one of the files that had been labelled a certain way was mistaken by a member of staff as being something else and was shared where it shouldn't have been. We took immediate action at that point, and the team reacted very quickly to that. We believe the situation was contained to and didn't immerse itself in the wider public, and we're currently doing an investigation just as to how that happened, and we will take lessons learned from that, and we will put those into place going forward. So absolutely, it's an error that we are sorry that happened, and we'd be more aware going forward of the need for us in a shared service to have all the controls that we need to in place for that.
Thank you for that. Trevor?
Thanks. I see in our briefing here 15 million additional funds for legal aid. What would that's for this year. What would that bring the estimated total bill up to?
The bill for legal aid falls between 95 and 100 million currently year on year. So the final figure each year isn't known until the very end of the year, but in the pattern over recent years has been 95 to 100 million.
That 15 is on top of that?
The 15 brings the legal services agency's budget this year up to about £94 million.
And what's the trend over the last 2 or 3 years?
As Anna said, the trend over the past number of years has been about £100 million or so. Last year was slightly under £100 million, mainly because of the withdrawal of services in the Crown Court that Ronnie referred to in his previous briefing. And actually that makes putting a figure on this year's forecast a bit more difficult, because we need to see how those pieces of work that were due to happen last year flow through into this year. So current budget is about £94 million.
I haven't been on this committee until now. There's been various attempts to try and rein in the legal aid budget or expenditure. Are you satisfied that you've had any success in doing that?
I think one of the big drivers, and colleagues from Access to Justice Directorate who are doing that reform piece of work will be much better placed to comment on that than me. But one of the drivers for the increased cost over the past number of years has been increased volumes as well. So the reforms that have been introduced have reduced legal aid spend, albeit that volumes have worked against that to a degree. Having said that, the Department has managed to provide sufficient funding over the past number of years to meet the total bill, but legal aid reforms continue and will continue. And as I said, colleagues will no doubt be briefing the committee on that over the coming weeks and months.
Maybe I could be asking the wrong people, but are you satisfied with the basics of the system as to how legal aid decisions are made, or how the application process?
I think the legal aid system is a hugely complex one. I suppose from a financial perspective, I'm best able to comment on the budget and how much funding we're providing them. I think to be fair to my colleagues, they'll be much better placed to answer your question about the complexities of how the actual system operates, if that's an acceptable answer.
That's right.
Thank you.
Doug?
Yeah, thank you for the briefing. It's really informative. I think, Mary, probably for yourself, in regards to Personnel Office and Service Division, you say that sickness absence is a challenge to the stage where you're going to establish a new unit within the division. Could you give us an idea of the scale of that challenge and where the pinch points are, and where you perceive the reason why we have those pinch points?
Certainly. Thank you for your question. Our target that was set last year, and Nisra works through on these targets, was to have 9.2 days. That was the target we had to try and achieve. Our estimated outturn last year was 15.9, so we were well above that target. That's the overall figure for the department with its agencies. When you actually look down into that figure, there are certain areas within the department which will have a much higher overall figure, and those tend to be the operational sides of the department. So our highest level of sickness is in the operational side in prisons mainly, and then Youth Justice Agency. We also have a high figure in, and I can give you those figures. It's last year for the Northern Ireland Prison Service, it was 20.9 days that were lost. And if you break that down between the operational side, which is the prison officers, you're talking about 23.8. And if you take the figure of non-prison grades, it's 9.9. So you can see that on the operational side, it's higher. In YJA, the figure was 17. And in LSA, which is the Legal Services Agency, which was a commission and had different policies, and which have now been brought into the department. It's a very high figure compared to other parts, because it's not, in a sense, an operation. It's much more into sort of more desk. It's 11.7, and in courts 10.8. So there's different elements, but you look overall, it's 15.9, but it's much higher in the frontline operational side of the department than elsewhere. There's a couple of other things that I would say in relation to sick absence. I think in common with all the other departments, we have a much older workforce than hitherto, and that's really been brought about because there's less recruitment and coming into the department. So our age profile of workforce is much older, and we are noticing that we have much more serious illnesses coming through in staff. In my own division, for example, I have 4 members of staff who've never had any absentee for sick absence, but I have one person who has been out with a stroke. I have another there's 2 people who've had heart attacks, and there's a lady with breast cancer. So there's much more serious illnesses coming forward, and there's a much greater now level of stress. People going out on various stress. And when you look at whether that stress is work-related or home-related, it's about 50-50. So some people are presenting with stress and as a reason for their absence, but it's not work-related, it's home or personal circumstances related. So there's quite a mixture. So we're conscious that we have to try and do something to try and minimise, but yet dealing sympathetically with those people who are genuinely out on sick, and we treat everyone who's out as a genuine case, and we try and do our best to get those people back to work. What we're now looking at is, and we've set up a specialised unit so that we can work much more closely with our line managers. We're also trying to, because of wellbeing issues, to try and identify people who might be under stress in the workplace and deal with it before we lose them and they go out on sick. So we're putting some interventions in around wellbeing and alerting sort of line managers what signs to look for, because if it's a personal home circumstance that is causing stress, it may not manifest itself in the same way because people may not want to have that conversation. So there are some difficult conversations, and we're trying to give our line managers the skills in which to have those difficult conversations with staff, and that's part of. So it's part of dealing with sick absence as by keeping in touch with the people involved and trying to find if there are ways of getting them back into work, any reasonable adjustments we can make that would encourage them back into work, and yet while people are in the workplace, trying to identify those who might be on that cusp of some intervention in work, could retain them in work rather than going out sick.
Thanks. I mean, that's a very full answer, and thank you for that. And 15.2 is high if your target is 9.2, and you can see how that can have an effect on budgets and your operational output. And I think it would be of concern. Have you set, and this is a difficult question to ask, but have you set a target for reducing that figure? Will we reduce it in 2 years? Will it be 4 years? Or is this just something that's a sliding scale that best we can do?
We are set, as all departments are, at targets at the beginning of the year. This year, because of that transitional towards the Centre of Excellence, I think the decision has been taken not to set specific targets, but to try and look at sort of more of the performance management as a way of trying to address it. But we are trying to prepare the department so that whenever the HR Centre of Excellence takes over responsibility in the 1st of April next year, that we are best placed. And as I've said, we have restructured within my division and within department, having our eye to what's happening in the Centre of Excellence, so that we're aligning ourselves to the functionality approach that they will be adopting. And we're hoping that in this year we will give ourselves an internal target to try and get it down more towards the 9.2, against a very difficult background where we have all these more serious issues to deal with, so that we're best placed when we move to the Centre of Excellence.
And just one more, Chair, if I may, and it's slightly off topic on this one, but do you have a whistleblowing policy?
We do.
Who heads up the whistleblowing policy? Who has oversight? And in particular, which is important to whistleblowers, is confidentiality, and what is the policy for breach of a confidentiality of a whistleblower?
We do have a whistleblowing policy, and we have it's on our internal website, and it's in line with the Northern Ireland Civil Service Centre, DOF, the central policy. So we're in alignment with that. We have 4 people who are named on that whistleblowing policy that people can get in contact. I'm one of the names, and there are 3 others that people can ring and have a confidential conversation. If immediately somebody raises a whistleblowing issue, they're invited in for interviews. Some people want to have anonymity. That's not always easy to achieve. We do try our best, if that's what they wish, to respect that anonymity. But if they're raising something and you obviously have to investigate it, it may not be easy to keep that anonymity. What we do, try if that is their preference, and certainly a full investigation. They're given the protection around their issues, so that if they discern that there's any reaction in their line of area of business, they can report immediately to us, and we will take steps to intervene. So they are protected, not just the individual, but sometimes they would have a family member in work or something like that, so it's wider than maybe just the person. But we certainly follow the full rigours of the whistleblowing policy and do a full investigation, keeping that person informed of what the outcome is, and providing any sort of thing that we need to do in the course of that investigation in support of them.
Thank you.
Thank you. Declan?
Thanks, Pam. Ryan, or Glenn, sorry, if I understood you correctly, you were indicating when you spoke that budgeting and forecasting would not fall within your remit with regard to legal aid. Did I pick you up correctly?
I think what I was saying was, well, I was answering Mr. Lunn's question about the size of the legal services budget this year. I don't think I touched on forecasting yet, but happy to take
but the quantum, the management of the quantum doesn't fall within your particular sphere of responsibility.
Given that we're now in a shared services environment where my division provides financial support to the Legal Services Agency, yes, some of my team do provide support to the agency staff in helping to pull together their forecast, if that's the answer to your question.
Auditory functions do fall within your remit, yeah?
Yes.
Okay. So could yourself and Leanne perhaps comment on your management assessment of the overall competence and structure of your auditing competence?
Of the competence of the department's internal audit function?
The audit management structure. Talk to us a little bit about the structure and the competence of that.
I can certainly talk about my internal audit team. I just want to be sure that there are actually auditors within the agency themselves who don't come under my remit, but I will very happily talk about the remit of the internal audit team for the department. So I've got 9 qualified internal auditors there. They're headed up at a grade 7 level. They're a mix of some are professionally qualified auditors and some are professionally qualified accountants. And between that team, they work up a programme, a 3-year rolling programme of audits to cover the departmental family, which will include Legal Services Agency and the other agencies and the core department. And they will agree those audit programmes then with the individual organisations, and throughout the year they'll report back to the audit committees in terms of progress against their programme. But as I say, their involvement, there'd be two sets of auditors in legal services. There would be my internal audit team, as I've described, and then there would be the Northern Ireland Audit Office who would come in and audit. But in addition to that, there is an internal team. I'm not sure whether they call them auditors, but there's some kind of a validation team within the agency themselves at the different checking stages. So I can come back to you with more detail if there's.
And to whom do they
I presume
report?
they report up to the chief executive, but I wouldn't want to mislead you in any way because I'm talking just as a general what I think here. I'd probably need to check the detail for you.
The chief executive of
the agency.
That's fine for now. Thanks.
Okay.
Thank you.
I can certainly come back if there's any more detail.
Yeah, I'm sure we'll talk about it further.
Okay. Thank you. Alex.
Thank you, Chair. It's just 2 requests for information and then 1 question. The first is to provide a profile, again, of age, gender, etc., of those who are being appointed under the public appointments process by the department, and the usual criteria and what that looks like, and that would be useful. Secondly, a breakdown of the costs to date in respect to Desert Creek. So not just the top line, but what the individual costs have been to date. And then my third question is when it comes to vetting. And I don't know what you can tell the committee in terms of what the processes are, or whether that's deemed to be confidential. But where does executive authority reside when it comes to making a call on whether somebody gets vetted at the various levels of vetting, including advanced vetting or whatever is the highest level? Where does the executive authority reside?
I think I'd probably need to come back to you on that. I don't have that information with me in terms of levels. Mary, do you have any?
We designate as a business area posts which would require higher security level clearance than others. There is a sort of an entrance security level that all civil servants have to acquire, and then above that in the Department of Justice we have a higher level again. And then in certain areas where there are posts which are deemed to have access to even higher security level material, people occupying those posts would have to go through what would be termed a developed vetting process, which is a higher level of security clearance in order to occupy that post and have the access to the information that that post has to have in order for the function to be delivered. All of the people who make application have to fill out a security questionnaire. That questionnaire then is we look to the police service to provide the security clearance or background. They will give us advice as to whether that person has a criminal record, or they will give us advice as to whether where that's the security on that person is. It's ultimately for the department to decide. Please don't say you cannot or can employ. They give you the information on which you then take the decision whether or not to employ that individual.
And where in the department does the executive authority reside? I know that you're all subject to the control of the minister, but when it comes to making the call in respect of any individual, especially in terms of developed vetting, who makes that call?
Initially, it would be the business area where whether that person would be able to they would accept that person with that security issue, if there was an issue, and it would be dependent on where that post is as to who would make that final decision. If it was of some complexity and seriousness, it probably would go straight up to, it eventually might go, depending on the seriousness and the post that is being considered, it would probably go up straight up to the head of department. But I'll double check all of that.
I think the question that you're asking is who takes the decision as to what the required level of security is?
No, who makes the decision about whether somebody is or is not developed vetted?
Right.
Ultimately.
Okay, I mean...
And does it go up to the head of department, which I presume it does, where it needs to?
Mm-hmm.
And then my final question is, say if, besides taking advice of the PSNI, which I understand, in cases of developed vetting, who else is consulted in respect of somebody who is seeking developed vetting? Another, for example, is the security service consulted?
I think I'd prefer to just come back to you on those issues because, as I say, Mary and I, we're very much the deliverers of the service. If I can put it like that, you know, we're instructed to do the vetting and we do the vetting, but around the decision making on those issues, it's not my area, so I would feel stepping out of line, but we can certainly write to you on that.
Thank you.
Okay, thank you. Any other members? Not, can I thank you all very much, and I know both Leanne and Glyn, you're staying with us for the next briefing.
Thank you.
But thank you for this one.
Thank you.
We're moving on to item 6, which is the Department of Justice budget session. And members, Leanne and Glyn are going to provide us an overview briefing of the Department of Justice 2016-17 budget. The relevant papers are at pages 127 to 160 of the meeting pack. The written briefing paper on the June monitoring round return provided by the Department for the first meeting of the committee has been included, as members indicated they may wish to seek further information or clarification on some issues. So again, you've been recorded by Hansard, you're well aware by now, and it will be available in the usual manner. So I don't know, is it Leanne again? You want to kick off and give us your case?
Okay, thank you, Chair. I'm speaking to the slide pack, which hopefully members will have in front of them. So thank you again for the opportunity to give a high-level overview today of the Department's finances. I'd like to turn firstly to slide 2 in the pack, which is the colourful diagram. This provides an overview of the Department's structure from a financial governance perspective. As you will be aware already, we have got 4 core directorates, and you'll have now received a briefing from each director on their area of work. But one of the features from the diagram that we'll note is that there are a range of agencies and NDPBs. So the pink line in this diagram are the 5 executive agencies. It's worth noting on that of the agencies, the DOJ has got 5 out of the total of 9 agencies across the whole of the NICS. So So it's a significant amount of agencies within one department. We also then, in the green boxes, have got 8 NDPBs, of which the largest by quite a share is PSNI. So this range of bodies adds to the complexities of our budget management, and the vast majority of our budget does not sit in the core, but is allocated across arm's length bodies belonging to the department. The next slide then shows how our budget is allocated. The vast majority of the budget, as I said, sits outside with non-departmental public bodies. 68% of our total budget, which amounts to 718 million, is the PSNI budget. 23% of our budget is allocated to the 5 executive agencies, the 2 largest being Courts and Tribunals and Prison Service. And again, this slide highlights that only a very small amount of our budget, 5%, circa, sits within the core department. The next slide then starts to show the engagement that normally finance team will have with the committee, and that's through the in-year monitoring round. There are usually 3 of these each year, and they're shown on the slide there. But if I take, for example, which will be our next monitoring round, we will be commissioning that very shortly for the mid-October executive meeting. So there is quite a timeline leading up to the monitoring rounds. We prepare that, it goes through the Internal Finance Resources Committee, then it goes to our own Minister in late September before coming to the committee for briefing in early October before the executive meeting, and usually around mid-October. So that will be certainly 3 stages of definite engagement with committee. But as well as that, as well as the in-year monitoring rounds, we also provide the committee with briefing on any specific issues as requested, and other key issues that we'll no doubt have regular engagement with in this next year will be the Budget 2016 exercise, which details are due to come out shortly as to the process that will follow. I'm now going to hand over to Glenn, who's going to take us through this particular year we're in a bit more detail. Thanks, Glenn.
Thanks, Leanne. If I can point you towards slide 5, that shows how the department's budget is broken down. So we've got a departmental expenditure limit, which is more commonly referred to as our DEL. There are 2 elements to this, our resource DEL and our capital DEL. Resource DEL is split into 2. We've got our on-ring-fenced resource DEL, and that's the budget for our staff costs, our other running costs and our programme costs. And that's the largest bit of our budget, which is 1051 million, or just over £1 billion. We also have our ring-fenced resource DEL budget. This is sometimes referred to as our non-cash budget, and that's a technical budget for things like the depreciation costs of our assets. That budget's £84 million. And then finally, we've got our capital budget, which covers investment in things like buildings, IT and vehicles, and we have £58 million this year for that type of expenditure. Slide 6 summarises the key feature of this year's on-ring-fenced resource DEL budget. In setting the 16-17 budget, the Executive protected the PSNI to a cut of 2%. The cut applied to the rest of the department's budget was 5.7%. And as I'll explain later, we have sought to protect frontline areas to a greater extent than this. And finally, and we've touched on this briefly, in recognition of the pressures on the legal aid budget, the Executive provided an additional £50 million towards this pressure. Slide 7 shows the Department also received voluntary exit scheme funding in 2016-17 for 4 bodies, and just Planning Appeals Commission and Water Appeals Commission transferred to the DOJ this year from what's now the Executive Office, and this body now forms part of the Courts and Tribunal Service. If I turn then to slide 8, you'll see that PSNI has received £32 million for additional security funding this year as part of the Fresh Start Agreement. This slide also outlines the funding that the Department will seek to bid to as part of the agreement. Fresh Start includes £5 million for tackling paramilitary activity from the UK Government, matched by £5 million from the Executive, and the Department will also bid to the £12 million of funding for a shared future. And as noted, the Stormont House Agreement included £150 million over 5 years for bodies to deal with the past, subject to agreement on their establishment. And this funding will be key for the department in dealing with legacy costs. Slide 9 simply summarises the makeup of our budget this year. As you can see, most of our baseline funding is from the executive, with additional amounts for voluntary exit schemes, again from the executive, and then the police security funding that I referred to. The chart on slide 10 summarises the in-year budget for the core department and each executive agency and non-departmental public body. Again, to reiterate the point that Leanne made, this slide highlights the number of bodies that make up the DOJ budget, and the fact that PSNI is by far the largest. As I mentioned, the department sought to protect frontline areas as far as possible in allocating our 16-17 budget. One of the ways we did this was by the core department taking a larger baseline cut than other areas of 9%. And as you'll see on slide 11, policing bodies have been protected to a 2% cut, in line with the police settlement. The Prison Service, Youth Justice Agency and Probation Board were protected to 2.9% cuts, and the voluntary and community sector was protected to 1.5% cuts. And the baseline changes by body are again summarised on slide 12. Two interesting statistics on the breakdown of our budget are shown on slide 13. Firstly, as Leanne mentioned, 68% of our total budget sits with PSNI. And secondly, and the percentages are coincident, 68% of our total costs, that's across the whole department and all of its bodies, relate to staff. So that was our resource budget. If I then move to slide 14, which is our capital budget, we have £58 million this year. Of this, £3.9 million relates to the Northern Ireland Community Safety College, and that was one of the flagship projects highlighted in the Executive 16-17 budget, where funding has been agreed up to 2021. And the final slide in your pack shows how our capital budget has been allocated to our spending areas. And as you can see, the two main allocations are for the police and the prison service. So in summary, I hope that provides a useful overview of the DOJ's finances, and we're of course happy to take any questions that you have.
Okay, thank you very much. That's very useful, and our deep appreciation for the nice, bright, clear, colourful presentations. We have a treat for us with these tablets. Very welcome indeed. Can I ask you first of all what you see as the key challenges in relation to the department's budget?
I'll maybe kick off and then I'll ask Glenn to add anything. One of the key challenges that I see is the point I mentioned earlier, that we've now completed the voluntary exit scheme last year, and for the NICS that's intended to be a one-year scheme, and 387 people left the department. But from a point of view of managing budgets, should there or if there was significant cuts that came centrally, for example, over the next 3 or 4 years, our ability to reduce our cost base, because 68% of the core is staff, it'd be quite difficult to quickly make deeper cuts without more people leaving, and more people leaving would be difficult on two levels, because one, from a capacity point of view, to deliver what we need to deliver, having lost 387 people would be difficult, but secondly, we have no money, if you like, to do exit schemes unless it's done centrally, and that scheme's only intended to be 1 year. So that's what I would see would be one of the challenges. The other challenge will be that we already do have some pressures in our frontline bodies already, such as prisons, policing, courts. We've already got pressures in there running baselines, and if there were to be more cuts centrally, then we would have a real difficulty in terms of managing the risks around some of those frontline areas. Those would be the two key things I would say would be our risks, Chair. But Glenn, is there anything else you'd like to add?
No, I think you're right. Over the last number of years, and again it comes back to the fact we have a very large range of bodies, and the department has sought to protect those frontline bodies as far as possible. But yeah, depending on what future budget settlements are, it's trying to find the right level of relative protection and where funding and savings can actually come from.
Okay, thank you. In the 16-17 budget, the department reduced funding to the voluntary and community sector by 1.5%, as you already mentioned there. How much did that equate in money terms?
Last year, if we start at this year, we're providing about £5.5 million to the voluntary and community sector. So it was around about £500,000 or so, like for like protection there. We also provide, it's worth noting, £2 odd million plus another 3 from the policing board to policing and community safety partnerships. So this year we're spending £5.5 million on the voluntary and community sector. Like for like, there was a reduction from last year, albeit we're working through, as a department, a piece of work at the minute looking at how we best engage with the voluntary and community sector, and working through what's grant funding, what's baseline funding and so on. So there's a much bigger piece of work there.
Okay. And did the agencies and the NDPBs, such as the Prison Service and Probation Board, also restrict any reductions in funding they provide to the voluntary and community organisations to the same level, do you know?
All areas were asked to protect areas, yes, to 1.5%.
Okay. The department received £3 million in the June monitoring round for central pressures. What will this funding be used for?
We plan to give £2 million of that to the court service, the area that Ronnie spoke to you about, and £1 million towards the prison service.
Okay, that's grand. A number of innovative approaches were identified by the previous Justice Committee in relation to problem-solving courts and online dispute resolution mechanisms. While saving money in the longer term, they'll require, obviously, upfront funding. What capacity does the department have to access this type of funding for such projects?
Where the executive proposes a change fund, the department will and has in the past made bids towards that. So if we look at the 15-16 year, for example, the department got some change fund funding for the Prison Service and Probation Board to, as you have said, pump primer, invest in initiatives that will hopefully both improve results and also take some costs out in the longer term. There is no access to any change fund funding as yet this year, but we'll continue to bid as and when that becomes available.
Thank you. Trevor?
Yeah, thanks. There's a figure there for Desert Creek this year, 3.9 million. Would that be the end of the department's responsibility for Desert Creek this year? Or are you going to have to allocate money in next year as well?
As I mentioned, Desert Creek was one of the flagship projects included in the Executive's 2016-17 budget, and that allocated funding for the project, which includes Prison Service, Fire and Rescue Service and Police Service up until 2020-21. So the 2016-17 budget allocated, I think, was £79 million of funding over that 5-year period, of which £3.9 million relates to this year.
But it appears now that the PSNI are out of the picture on Desert Creek. And the other bodies are not the responsibility of the DOJ. So are you still having to allocate capital money looking into the future, even though it's no longer going to be your responsibility?
Well, I think the funding that was allocated will be for the project as a whole. And as the business case is firmed up and the final governance structures are put around that project, that line of funding, if you like, subject to working with Department of Finance colleagues, that line of funding will be allocated in the agreed amounts to the respective bodies involved in the project, but that's something we still need to finalise with Department of Finance colleagues.
So, well, have you any idea of how much the whole project will have cost the Department of Justice when all the dust settles, even though you're not actually getting anything out of it?
I know that offhand, I know the total cost of the project, and as I said, up until 2020-21, 2021, there's £70 million. There will be another requirement in the subsequent year, but I need to come back to you with a specific breakdown across the various bodies involved in it, if that's okay.
And the only figure I'm interested in really is what will it have cost DOJ whenever the whole thing's finalised.
Okay, we'll certainly come back to you with that information.
Okay, Doug?
Yeah, just before I ask you the question I was going to ask, just to follow on for what Pam asked you, you've got £3 million in the June monitoring, and you kindly told us what that was for. What did you ask for?
We put a bid in for the £3 million. We also flagged or requested access to funding, it's in your note, to some other funding sources, for example, Fresh Start funding. I suppose the other main element of our request, but we did note, and it comes back to the question about the legal aid forecast, this was based on a very early assessment of the legal services requirement. Legal Services Agency flagged a pressure this year of £6.6 million on legal aid, but that is the actual quantum of that is very much going to be based on what comes in relation to the withdrawal of services in the Crown Court last year. So it's too early to say how much that actual pressure will be this year. That's something we need to keep an eye on over the rest of the financial year.
So a quick one. The three-person panel on paramilitarism has kicked up a number of recommendations. Many of those recommendations fall to the department. I think it's 13, and some others were implied input onto them. Does your budget have the resilience to deal with them? When we look at the amount of money that's been set aside, £10 million for tackling paramilitary activity, but that's not all coming here, that's just for to be able to bid into. Do you see any major long-term pressures or short-term pressures if we adopt all of those recommendations?
I think the full quantum of the recommendations is probably something that still needs to be worked through. What we did request access to in June monitoring was access to just over £1 million of that funding. So on the basis that we have access to that funding to date, we're able to absorb those costs.
All of the recommendations that are.
Well, just to clarify, we're able to absorb the costs that have been flagged to date. There's a cross-departmental group that the DOJ chairs that's considering all of those recommendations and so on. So there's work needs to be done to quantify that. But to date, the cross-departmental group has looked at specific DOJ costs of about £1 million, and we've been able to access funding for those. So it'll probably be the next monitoring round when I'm able to come back and say, here's the amount the department needs and what it's requesting access to from the available funding.
Good enough, thanks.
Okay, thank you. Alex?
Thank you, Chair. The first question is that there's been questions and answers previously in the last couple of weeks in respect of the PSNI bid for extra money arising from Fresh Start in order to deal with organised crime. And if you could provide an update to the committee as and when that begins to mature. I understand that the bid is in, but when it is, I don't know what the process is going to be, whether it needs just approval within the department or at the executive level, or it has to go across to the Treasury or something like that.
You can come back to you in writing.
Yeah, that's fine. Then the second question is, our colleague Jerry Mullen, in his maiden speech at the Assembly on Tuesday, raised and inquired about where we are in terms of a new prison, and that's not detailed in the Capital Bell budget line.
If I can find the right page, the prison service budget this year is £17 million, included.
15.
Sorry?
Slide 15.
So yeah, on slide 15, there's £17 million for prisons. Included within that is funding for constructing a new accommodation block in Magabry. So the necessary funding for that accommodation block is included in the prison service budget this year. That's obviously a multi-year project. And as we look ahead to the next budget period, yes, the department will no doubt be trying to access funding for further development of the prison service estate.
There's nothing in terms, besides the block at Magabry, there's nothing else, certainly not in 16-17.
Nothing else significant. There's obviously funding for works across the prison estate, but nothing else of that level of funding.
It'd be worth saying that in the last mandate, quite a lot of detailed business cases were prepared for the general prison estate, which cover looking at the prison estate in its entirety. And those business cases, if you like, are sitting on the shelf ready to be drawn against, and they'll form a big bit of what we look at whenever we're trying to put together the capital budget for the next number of years. So it's this bit of money that we've got this year is a bit of that, but it's by no means the whole picture.
Well, obviously, with the programme for government and the budget coming at the end of the year, we'll see where all that travels over the next time. You mentioned but didn't explain this review going on in the department in terms of monies to voluntary and community groups, whether it be grant-aided or baseline. Share some of the thinking of where the department thinks it should go.
Colleagues in our Assistant Justice Directorate are again taking that piece of work forward. I suppose at a high level, it's essentially about trying to make sure that we make the best use of our funding in terms of engaging with the voluntary and community sector. As I said, plan to spend about £5.5 million across all our bodies this year. So it's looking at how that work's commissioned, how we best engage with the sector, and as part of that process, there are colleagues in the department engaging with the voluntary and community sector as we take that forward.
It's probably not a fair question, Chair, because it's a finance one rather than, and you can't answer the policy one. But I do want to put down a marker that I have the sense that central government is more and more going to try to bring into central government the delivery of services that have previously been devolved to outside central government, including into voluntary and community organisations, and that there is this instinct to centralise in order to control rather than the best model for delivery, which is very often community and voluntary in character. So I just want to put down a mark from my point of view that if that is the outworking of this review about best use of resources that heretofore have gone to the community and voluntary sector and ends up actually being centralised, then whilst I'm prepared to hear the argument, my judgment is to be very cautious and vigilant against that approach. I think there is going to be this tendency over the lifetime of this mandate to centralise in order to control, and that mightn't, very often isn't the right way to deliver best services, be it on the justice side or in other aspects of government. And the final question, Chair, is no plans to reactivate the Law Commission?
I'm not aware of any plans to change it from what it currently is, which
It doesn't do anything at the moment.
is still in existence, but there's, as far as I know, there are no plans to change that remit at the minute.
Not to change the remit, it's for to do any work. At the moment, it's not doing any work, isn't that right?
I'm not over that area of responsibility. That's another director colleague, but I can certainly.
Okay. I think it is the case that the Law Commission isn't doing any work because of budgetary issues. I just need to know. There doesn't seem to be any provision in the budget line to make it do any work this mandate this year or next.
Not in 16-17, but we'll certainly speak to colleagues involved and come back to you.
Thank you.
Further questions? Thank you very much, Leanne and Glenn, for all your presentations today. Thank you. Okay, members, we're just moving on to item 7, which is legislative consent motions, policing and crime bill. And just to say, the rest of the agenda is quite a number of items, but we'll try and move through them as quickly as possible if you bear with us. I refer you members to pages 162 to 183 of the meeting pack for the relevant papers, and inform you that the Policing and Crime Bill was introduced at Westminster on the 10th of February 2016 and completed report stage in the House of Commons on the 13th of June 2016. It will now be considered by the House of Lords. The bill is in 9 parts, and its purpose includes to further improve the efficiency and effectiveness of police forces, enhance the democratic accountability of police forces, build public confidence in policing, and ensure that the police and other law enforcement agencies have the powers they need to prevent, detect and investigate crime. So, members, that the bill contains policy proposals which the Department of Justice believes a strong case exists for extension to Northern Ireland. The Department is therefore proposing to extend the policies by way of 3 legislative consent motions covering the maritime enforcement powers for law enforcement officers in England, Wales and Scotland in hot pursuit situations in Northern Ireland waters, cross-border powers to allow police officers in England, Wales, Scotland and Northern Ireland to arrest a person in their own jurisdiction for a serious offence committed in another jurisdiction, and amendments to the biometric retention statutory framework to provide for the retention of DNA and fingerprints from a person on the basis of a conviction outside the UK. So, members, just advise you that the discussions are ongoing between the Department and the Home Office with regard to the accountability arrangements for the hot pursuit powers in the bill. The bill, as currently drafted, contains a clause which has the effect of extending the jurisdiction of the Independent Police Complaints Commission in England and Wales to the hot pursuit powers in both the Modern Slavery Act and this bill. Members, just to inform you that this is contrary to the position the previous Assembly provided legislative consent for in relation to the Modern Slavery Act. The MSA memorandum provided consent for the Police Ombudsman of Northern Ireland to investigate any complaints made against officers from police forces in England and Wales in the exercise of hot pursuit powers in Northern Ireland waters. Also, that discussions are ongoing between the Department and the Home Office with regard to the accountability arrangements for the hot pursuit powers in the bill. The Home Office is aiming to bring forward amendments in the House of Lords to clarify the Independent Police Complaints Commission's jurisdiction to reflect whatever arrangement is reached. So, I think, members, given the lack of clarity around the accountability arrangements, this committee, with your agreement, may wish to propose that the committee schedules an oral briefing by departmental officials on the proposed LCMs. If that's an agreement, the oral briefing would be scheduled for early September, but by which time then hopefully the discussions between the Department and the Home Office may have reached a conclusion. So, yep, good, thank you. We'll move on to item 8 then. It's an SR 2016-197, the Criminal Defence Services General Regulations Northern Ireland 2016. That's available in your packet 185 to 192. Members, to remind you, at the meeting of 9th of June 2016, the committee agreed that it was content with the policy elements of the statutory rule 2016-197, which provides that the Court of Appeal may grant a right to representation under Part 2 of the Access to Justice Northern Ireland Order 2003 in respect of criminal appeals in the Court of Appeal and the Supreme Court, and in the case of an appellant who is to be retired before the Crown Court. I advise you that the Examiner of Statutory Rules has now indicated that she has no issues to raise with regard to the technical aspects of the rule. So, members, are you content with the statutory rule? And if so, I'll put the question, which is that the Committee for Justice considered SR 2016/197, the Criminal Defence Services General Regulations Northern Ireland 2016, and has no objection to the rule. Great, thank you. On to item 9, which is SR 2016-198, the Criminal Defence Services Remuneration Order Northern Ireland 2016, and you'll find that in your packs, members, at 194 to 206. Just to remind you, on the 9th of June, the committee agreed that it was content with the policy elements of the statutory rule 2016-198, which provides for the remuneration payable to solicitors and counsel for providing representation under Part 2 of the 2003 order in respect of criminal appeals in the Court of Appeal and the Supreme Court, and deals with the manner in which the remuneration is to be determined and paid. The Examiner of Statutory Rules has now indicated she has no issues to raise with regard to the technical aspects of the rule. Are members content with the statutory rule? And if content, then I will put the question that the Committee for Justice considered SR 2016/198, the Criminal Defence Services Remuneration Order Northern Ireland 2016, and has no objection to the rule. Okay. And on to item 10, we have SR 2016-200, the legal aid for the Crown Court proceedings costs amendment rules Northern Ireland 2016, and you'll find that members at pages 208 to 224 of their meeting pack. On the 9th of June again 2016, the committee agreed it was content with the policy elements of the statutory rule 2016/200, which provides for the revised legal aid remuneration arrangements for defence representatives undertaking work in the Crown Court. The examiner of statutory rules has now indicated she has no issues to raise with regard to the technical aspects of the rule. Members content with the statutory rule? And if so, I'll put the question that the Committee for Justice considered SR 2016/200, the legal aid for Crown Court proceedings costs amendment rules Northern Ireland 2016, and has no objection to the rule.
Agreed.
Agreed. Thank you. On to item 11, SR 2016-201, the legal aid for Crown Court proceedings cost amendment number 2, rules Northern Ireland 2016, and you'll find that members in your packet 226 to 235. At the meeting on 9th June 2016, the committee agreed it was content with the policy elements of Statutory Rule 2016-201, which will introduce provisions into the Crown Court to provide remuneration in cases where the circumstances of the case are so exceptional that the cost of presenting the case cannot be properly remunerated under the existing matrix of standard fees. The examiner of statutory rules has now indicated that she has no issues to raise with regard to technical aspects of the rule, so if members are content with the statutory rule, I will put the question.
Sorry, Chair, does that one mean that if exceptional circumstances, does that just mean that you have to take longer over it? Maybe Alex can help me here. Or does it mean that there's some exceptional, particularly detailed work to be done? Because it seems to me that these are rates per hour according to the particular level of expertise required. So why exceptional costs? Because it's not just catered for by the extra hours.
Clerk will brief us on that.
This stat rule arose out of a judicial review where the department was taken for judicial review.
Yeah,
several judicial reviews, and the court ruled that the standard matrix of fees, in particular exceptional as they described it circumstances, didn't properly remunerate the work. So this rule is bringing in a mechanism to allow the department to remunerate, but it's in fairly very specific tight circumstances where the cases are, I suppose, way outside the norm. So it's not just for extra additional hours or whatever. And I think the rules set down, and they've kept it as tight as they possibly can, but they are required to bring in some mechanism to remunerate in certain circumstances where the court has decided that the standard fee regime won't provide the necessary remuneration. The department is under law required to provide remuneration that is adequate for the work carried out. So in a number of circumstances, I think there was 2 or 3 judicial reviews, they lost the judicial reviews and they were required to bring this in.
I think the figure I saw for a senior counsel was £130 an hour. So if there's exceptional circumstances which involves them in longer hours of work, they'll still get £130 an hour for all the hours worked, but they're going to get something on top of that because the circumstances were exceptional. Is that the way it works?
Chair.
Yes,
it's really where there's additional preparation work needed because the case involves a point of law or a factual issue that's unusual or novel. So there's a lot more preparatory work that needs to be done. So regardless of what the payment is per hour, this is just a different. It's extending that. It's allowing the extra money to be paid for the additional hours worked.
They actually have to be granted a certificate of exceptionality before they can apply for that, and there is those tight circumstances. I think under the previous Justice Committee, the department did consult and spent quite a bit of time trying to make sure that the areas where you could get paid for exceptional circumstances were very small, and they've tried to keep it as tight as they can. And it is where I think where there is involves a point of law or a factual issue that is very unusual or novel, and they have to apply for this certificate of exceptionality before they will be paid.
So if you put it in the sequence, say the department tried to reduce the amounts were being paid. The legal profession, or a section of them, went on strike. The Lord Chief Justice asked them eventually to head into mediation between the department and I think the Bar Council, and the upshot is they're getting more instead of less.
Well, I think the actual, when they went off the record, that was to do with an overall reduction in the general and the fees paid under the standard matrix. This was a separate issue where the cases were based on that the standard matrix didn't remunerate for the particular circumstances of certain cases. So the two things were slightly different.
Okay. I'm coming back as a QC.
Okay, thank you. So if members are content, then I'll put the question.
Yep.
Okay. Yep. And that the Committee for Justice considered SR 2016/201, the Legal Aid for Crown Court Proceedings Costs Amendment Number 2, Rules Northern Ireland 2016, and has no objection to the rule.
Agreed.
Great, thank you. Moving on to agenda items 12 to 22, SL1's proposals for subordinate legislation. Members, a number of consequential amendments are required to subordinate legislation, and 2 acts as the consequence of the ongoing implementation of the Justice Act Northern Ireland 2015, which received royal assent in July 2015. Members, the Department has provided 11 proposals for subordinate legislation for the Committee's consideration. These can be found at the agenda items 12 to 22. All the SL1s outline non-controversial, technical, consequential amendments in preparation for implementation of the jury's provision and the single jurisdiction provisions of the Justice Act Northern Ireland 2015. So moving on to 12. So, yes. So moving on to item 12 itself, the SL1, the Juries Amendment Regulations Northern Ireland 2016. And that can be found in your pack, members, at 239 to 243. Advisory, the Department proposes to make a statutory rule to amend the Juries Regulations Northern Ireland 1996 so that the details set out in the prescribed juror notices will correspond with the amendments made by Section 77 to 81 of the 2015 Justice Act, which removed the current jurors' upper age limit of 70 and updated the list of those who are disqualified or ineligible or excusable as of a right for jury service. So just inform members that the proposed statutory rule is not introducing any new policy. It will purely make consequential changes to ensure that the regulation will continue to be relevant on the implementation of the Justice Act provisions. Members, are you content with the proposed statutory rule, or whether you require any further information on that? Great, okay, thank you. Agenda items 13 to 19. Which are SL1s to amend court rules, and tend to cover the agenda items 13 to 19 altogether, as they're all related. Okay, so you'll find these in your packet 245 to 285. The Department proposes to make 7 statutory rules that are necessary in light of provisions introduced by Part 1 of the Justice Act 2015, which will abolish the county court divisions and petty sessions districts, thereby creating a single jurisdiction for the county courts and the magistrates' courts. Members, the proposed statutory rules do not represent any changes in policy. They are purely consequential, technical amendments to remove terms county court division and petty sessions district and related references where they appear in court rules. So, members, are you content with the following statutory rules, or do you require any further information? And that, just to recap, is the SL1, the Magistrates' Courts Amendment Number 2 Rules, Northern Ireland 2016, the SL1, the Magistrate Courts Miscellaneous Amendments Rules, Northern Ireland 2016, the SL1, the County Court Amendment Rules, Northern Ireland 2016, the SL1, the County Court Miscellaneous Amendment Rules, Northern Ireland 2016, the SL1, the Crown Court Amendments Rules, Northern Ireland 2016, the SL1, the Crown Court Criminal Procedure and Investigations Act 1996, Tainted Acquittals Amendment Rules, Northern Ireland 2016, the SL1, the Rules of the Court of the Judicature, which is a hard one, Northern Ireland Amendment 2016. Exhausted about that. Members, are you content that those statutory rules, Or do you require any further information? Okay. So agenda items 20 to 22, SL1s to amend Court Rules Acts. Intend to cover the items 20 to 22 as they are related, and I can refer the members to pages 287 to 303 of the meeting pack. The Department proposes to make 3 statutory rules that are necessary in light of provisions introduced by Part 1 of the Justice Act 2015, which will abolish county court divisions and petty sessions districts, thereby creating a single jurisdiction for the county courts and the magistrate courts. As a consequence of these changes, the terms Divorce County Court and Civil Partnership Proceedings County Court were also abandoned under the provisions in the 2015 Act. Members, the proposed statutory rules do not represent any changes in policy yet again. They are purely consequential. They are technical amendments to remove the terms County Court Division, Petty Sessions District, Divorce County Court and Civil Partnership Proceedings County Court, and related references where they appear in either the Court Rules, Psychoactive Substances Act 2016 or the Justice Act 2016. So members, are you content with the following proposed statutory rules, or do you require any further information? And that is the SL1, the Family Proceedings Amendment Rules, Northern Ireland 2016, the SL1, the Justice Act, Northern Ireland 2015, Single Jurisdiction, Consequential Amendments Order, Northern Ireland 2016, and the SL1, the Justice Act, Northern Ireland 2015, Single Jurisdiction, Consequential Amendments Number 2, Order Northern Ireland 2016.
Yeah.
Thank you. And moving on to agenda 23, the Sentencing Policy Review. I refer you to pages 305 to 314 of your pack. Inform you that the Department of Justice has written advising that the Minister has asked officials to undertake a comprehensive review of sentencing policy issues. She is of the view that it is now timely to review progress under the current sentencing guidelines mechanism introduced in June 2012 to assess whether it is meeting the objectives of enhancing public confidence, consistency and transparency in sentencing, and to look at various wider issues within the sentencing framework. Members, the details of the review are contained in the terms of reference, which can be found at page 310 of the meeting pack. If the review recommends changes to the current sentencing arrangements, the proposals will be subject to a public consultation. Okay. Pat, were you wanting in with this?
Yeah, no, just in line with the questions in the clerk's memo, can we ask for a timescale for the review and what groups are going to be consulted? And just as a matter of interest, do these reviews, as a matter of course, engage with political parties?
Sure,
Do you know that, Pam?
I don't know. That's clerk. Do you?
No, I don't know. We can ask.
We can check.
And are we asking for a research paper on international good practice in terms of sentencing? Can we ask the research department for that?
We've one here. Okay, if I read out what the clerk has suggested here for us, it's the specific timescales for the completion of the review, a list of statutory agencies, voluntary organisations and interested parties the department intends to engage with, whether the terms of reference will be published on the department's website to provide an opportunity for any individuals or organisations who wish to make a contribution to the review to do so, clarification of whether the review will consider the use of community sentences as an alternative to short prison sentences, and then we're going to ask whether the committee would agree to a request for an oral briefing from the department on the evidence gathered during the review and any proposed changes put forward by participants, and also to seek the members' agreement to commission a research paper on sentencing guidelines, mechanisms in place in other jurisdictions, models of good practice and approaches employed to secure public confidence in sentencing, to assist the committee's future consideration of the outcomes of this review. Are you happy enough with that?
And that good practice is sort of focusing on the international element then, as Richard was saying?
Yeah, what we'll do is we'll talk to our researchers and we will ask them to look across the board, but generally what they'll try and do is look for examples of similar similar situations to here in Northern Ireland. Sometimes when they look for examples elsewhere, while they're interesting, they may not be able to be applied because of our particular setup. So they try to look at jurisdictions with similar justice systems, so that you can look like for like. But we will ask them to look for any good practice
Good
examples.
aspirational standard.
Okay, members? Okay, let's move forward on to agenda item 24. That's the Witness Charter for Witness of Crime draft consultation document. Members, you'll find this in your packet 316 to 427. Members, the previous Justice Committee inquiry into the criminal justice services available to victims and witnesses of crime in Northern Ireland 2002 called for a victim and witness charter providing statutory entitlements for victims and witnesses in terms of information provision and treatment. Members, the previous Minister of Justice accepted the committee's recommendation and the Department committed to the development of a separate victim and witness charter in its 5-year victim and witness strategy launched in 2013. The Department subsequently introduced the victim charter on an administrative basis in January 2015 and placed it on a statutory footing in November 2015. Members, the Department has now developed a draft witness charter which aims to provide witnesses with better quality services taking account of individual circumstances and make clear, relevant information relating to key stages of the criminal justice process. The Charter consists of 11 sections setting out the information and services to be provided to a witness and the standards they are entitled to receive. Members, subject to the views of the committee, the Department intends to consult on the draft witness charter and associated versions. So, members, are you content to note the consultation document and draft witness charter and the associated versions and consider the matter further when the results of the consultation are available? Or do you wish to submit any comments, or are you looking for any more information at this stage?
Happy at this stage, Pam,
okay.
With the consultation, but could we get a copy of the previous committee's report and findings from June 2012?
The inquiry, certainly.
Please. Thanks.
Okay. Moving on to agenda item 25, the correspondence. There were 3 items of correspondence at pages 429 to 469 of the meeting pack. Members, are you content to action the items of the correspondence as set out in the cover sheet, or do you have any comments to make on any of them?
Chair, do we have any reply from the Permanent Secretary about an update on where the health-led review of what's to happen in terms of mother and child, and inquiry into mother and child homes, and inquiry into victims of clerical abuse outside the institutions? This is raised with the Permanent Secretary a couple of weeks ago.
I think there's timescales set down for responses. I think it's due tomorrow, so we're keeping an eye on it.
Okay, so members, we're content to note the correspondence?
Yeah.
Item 26, Chairperson's Business. There are currently no items for Chairperson Business, you'll be pleased to know. Item 27, any other business? Do we have any other business? Alex?
Chair, the first thing is, given the day that's in it, I think the committee should at least express their sympathy to Jo Cox and her family. This is the MP who was shot and stabbed this afternoon, critically ill in hospital. So I think the committee should express their sympathy with the family and perhaps send some correspondence maybe to the relevant committee in London or to the leader of the Labour Party in order to acknowledge the gravity of what's happened and hope that she makes a recovery. And the second, much more mundane, is I know a number of committees have cancelled their meetings for next Thursday and for next Wednesday, given the EU referendum, and that's certainly my wish that this committee would meet next in order to enable people to attend to their duties.
Well, on the first issue, I'm sure there'd be no problem in actioning that, as you've suggested. I think those comments are very good. And the second issue, we're actually meeting on, we've already agreed to meet on Tuesday, to have a brief meeting on Tuesday at lunchtime, 12:30, I think? 12 o'clock.
I thought somewhere in the back.
So it only should last half an hour, so we won't be meeting on Thursday.
Okay, great.
Okay. No other business? No? That's great. So, M28, date, time and place of next meeting. As we've just said, it will be on Tuesday 21st of June, 12 p.m. in room 30.
This is the Northern Ireland Assembly